In the early 2000s, pagers were a staple for first responders, a lifeline buzzing with crucial information. For Jeff Quon, a SWAT sergeant with the Ontario, California Police Department, his pager wasn't just a work tool, it was a direct link to his personal life. Little did he know, this small device would ignite a national debate about privacy in the digital age, a debate that would reach the highest court in the land. This is the story of City of Ontario versus Quon, a case that asks a simple yet profound question. When you use a work device, where does your privacy end and your employer's right to know begin? Our story starts in 2001. The City of Ontario issued pagers to its police officers, including Sergeant Jeff Quon. These weren't just for emergency alerts. They could send and receive text messages. Think of them as the early ancestors of our modern smartphones. The city had a clear policy. These devices were for official business, and they reserved the right to monitor all network activity. They also warned employees that they had no reasonable expectation of privacy when using city equipment. Initially, the city's wireless contract had a character limit for text messages, 25,000 characters per pager per month. If an officer went over that limit, they had to pay the overage fees themselves. Sergeant Quon was a frequent overage user. He found himself paying the extra charges month after month. At one point, Quon's supervisor, Lieutenant Stephen Duke, got tired of collecting the overage payments. He told Quon something that would become a crucial point in the legal battle to come. According to Quon, Duke said that as long as Quon paid the overage fees, his messages would not be audited to see if they were work-related. Essentially, it was a don't ask, don't tell policy for pager use. This informal agreement seemed like a practical solution at the time. Quon continued to use his pager for both work and personal messages, and he continued to pay for the extra usage. But in 2002, the situation changed. Lieutenant Duke, still frustrated with being a bill collector, decided he needed to figure out if the character limit was too low for actual police work. Was Quon's high usage due to his SWAT duties, or was something else going on? Duke asked the city's wireless provider, Arch Wireless, for a transcript of Quon's text messages for a 2-month period. The city obtained the transcripts. What they found was startling. Out of 456 messages sent and received by Quon during 1 month, the vast majority, over 400, were personal. Many of them were sexually explicit, exchanged with his wife and his mistress, both of whom also worked for the police department. When the police department discovered the nature of the messages, they launched an internal affairs investigation. Quon was disciplined for violating department policy, but Quon didn't take this lying down. He, along with his wife, his mistress, and another officer he had messaged, sued the city. Their claim was simple. The city had violated their Fourth Amendment right to be free from unreasonable searches and seizures. They argued that because Lieutenant Duke had told them their messages wouldn't be audited if they paid the overage fees, they had a reasonable expectation of privacy. The legal journey began. The case first went to a U.S. district court. The court sided with the city, ruling that the search of the text messages was reasonable. The court believed that since the pagers were city property and the city had a policy allowing for monitoring, Quon and the others couldn't reasonably expect their messages to be private. But Quon appealed. The case then moved to the Ninth Circuit Court of Appeals, a court known for its more liberal interpretations of privacy rights. And here, the tide turned. The Ninth Circuit reversed the lower court's decision. They agreed with Quon. They found that the informal policy, the one where Lieutenant Duke said the messages wouldn't be checked if Quon paid the overages, had created a legitimate, reasonable expectation of privacy. The court ruled that reading the content of his personal messages was a significant intrusion, and therefore, the search was unconstitutional. This was a huge victory for employee privacy advocates. It suggested that even with a formal policy in place, an employer's informal practices and assurances could create a protected privacy interest for employees. The City of Ontario, however, was not ready to give up. They saw this ruling as a major threat to their ability to manage their employees and resources. If this precedent stood, how could any public employer investigate misconduct or ensure that government property was being used properly? So, they appealed to the highest court in the United States, the Supreme Court. In 2010, the Supreme Court heard the arguments in City of Ontario versus Quon. The courtroom was filled with anticipation. This was one of the first major cases to tackle the issue of digital privacy in the workplace. The justices were tasked with applying a constitutional amendment written in the 18th century to the technology of the 21st century. The central question remained: did Jeff Quon have a reasonable expectation of privacy in his text messages? And if he did, was the city's search of those messages reasonable? The city argued that its search was justified for a legitimate, work-related purpose, to determine if the 25,000 character limit was sufficient for police work. They claimed they weren't on a fishing expedition to find misconduct. They were trying to solve a logistical and financial problem. They also pointed back to their official policy, which explicitly stated that employees had no expectation of privacy. Quon's lawyers countered by focusing on the informal agreement with Lieutenant Duke. They argued that this created a new understanding, one that superseded the formal, written policy. They claimed that the search was excessively intrusive because the city could have achieved its goal without reading the actual content of the messages. For example, they could have simply counted the number of personal versus work-related messages without digging into the explicit details. The Supreme Court justices seemed cautious. They recognized they were navigating uncharted territory. Justice Anthony Kennedy, writing for a unanimous court, acknowledged the challenges of applying old legal principles to new and rapidly evolving technology. He wrote, "The court must proceed with caution when considering the Fourth Amendment's application to the search of electronic data." In a decision that surprised many, the Supreme Court sidestepped the big question of whether Quon had a reasonable expectation of privacy. They essentially said, let's assume for the sake of argument that he did. They chose not to make a sweeping ruling on digital privacy that might quickly become outdated. Instead, they focused on the second part of the question: was the search reasonable? And on this point, the court was clear. They ruled unanimously in favor of the City of Ontario. The court found that the search was reasonable because it was motivated by a legitimate work-related purpose. The city needed to know if it should pay for a more expensive service plan with a higher character limit. Auditing the messages was an efficient way to find out. The court also noted that the search was not overly intrusive. The review was limited to just 2 months of messages, and it was conducted to determine the business use to personal use ratio. The fact that they stumbled upon sexually explicit content was incidental to their legitimate goal. Therefore, the search did not violate the Fourth Amendment. The Quon decision was a landmark, but not in the way many expected. Instead of creating a broad, new rule for digital privacy, the Supreme Court took a narrow, fact-specific approach. They gave a win to employers, confirming their right to monitor employee communications on work-issued devices for legitimate, work-related reasons. So, what is the legacy of City of Ontario versus Quon? For employers, it reinforced the importance of having a clear, written policy about monitoring electronic communications. It also showed that such policies generally give them the right to check how their equipment is being used. For employees, the case served as a major wake-up call. It made it crystal clear that when you use a device provided by your employer, your privacy is limited. The line between personal and professional life blurs significantly. The convenience of using one device for everything comes with the risk that your boss might be reading. The world of technology has changed dramatically since Quon sent those text messages. We now live in an era of company-provided smartphones, laptops, and cloud accounts. The principles from the Quon case are more relevant than ever. Every email you send on a work account, every file you save on a company server, and every message you type on a company phone could potentially be seen by your employer. The Supreme Court's cautious approach in 2010 left many questions unanswered, and courts continue to grapple with these issues as technology evolves. But the story of Sergeant Jeff Quon and his pager remains a foundational tale in the ongoing saga of our digital lives, a powerful reminder that in the workplace, privacy is not guaranteed. It's a balance, and the scales often tip in favor of the employer. Thanks for watching. If you found this story interesting, don't forget to like this video and subscribe to our channel for more deep dives into the cases that shape our world.